Hi, I'm Michael Boucher, Managing Partner of TCS. Our firm is a complete litigation and trial support firm providing services to the legal community throughout the nation. Our staff is comprised of consultants, animators, artists, paralegals, videographers, trial techs, and others. Here's a list of our services at TCS, including trial techs and audiovisual equipment rental, virtual case facilitators, and 3D printing. Our artists will bring visual concepts to life in simple chronologies or more complex timelines. The annotation of radiological films, colorization of injury and hardware, explanation of anatomical procedures and features. Our design team can bring static evidence to life, as you're seeing here in a fetal strip monitor being animated, as well as an explanation and tutorial of what data encryption is, how it works in the context of a jury trial in federal court. Our animators can recreate any scene and bring it to life at trial. This animation illustrates the use of photographic scenery to give it the real-life feel and look to help you prevail in your litigation. TCS also offers complete video recording and editing, including photography and videography, video and Zoom video depositions, IMEs, documentaries and day in the life, site surveys, video editing enhancements, drone video and photography. Trial boards have been a staple in the courtroom for decades now. Even with the advent of technology and electronic publication of evidence, trial boards still have an important place in the courtroom. One of the nice things that TCS does with our large boards is ensure that they're hinged in a proper way to conceal the content and easy transportation to and from the courthouse. Welcome to our newly renovated space here at TCS. It's an open, versatile, almost 800 square feet of meeting space. Welcome to our mock courtroom, all set up for an upcoming mock trial. Let me take this opportunity to talk to you a little bit about TCS's research in both jury consulting and trial research. Our consultants will meet with your team to discuss themes and strategy. We'll also do research in the form of attitudinal surveys, focus group, venue analysis, mock trials, and jury selection. And when it comes to jury selection, yes, we've been there a time or two before. All of us here at TCS look forward to working with you and your team.
Hello, and welcome again to PAF's Fall Seminar. It is my pleasure to introduce you to Circuit Judge David Frank. Judge Frank earned his Bachelor of Science from the United States Military Academy, West Point, and his Master of International Public Policy from Johns Hopkins University's School of Advanced International Studies in Washington, D.C., and his Juris Doctorate with high honors from the Florida State University's College of Law. Judge Frank served as a United States Army Infantry Platoon Leader and Special Forces Green Beret Detachment Commander with assignments at Fort Bragg in North Carolina and overseas services in Central America. After his military service, Judge Frank was an intelligence analyst for the Central Intelligence Agency, where he authored classified publications and provided briefings to policymakers that included the President, Vice President, Cabinet members, the National Security Council, Congress, and other senior executive branch officials. Judge Frank began his legal service as the state of Florida as an assistant attorney general, where he represented the governor and state agencies in complex class action lawsuits in federal and state courts. He then founded and managed his own law firm, where he represented clients in every county in our circuit, and was the lead trial counsel for numerous jury trials in state and federal court. His recognition as an attorney includes U.S. News and World Report Best Lawyers in America, and Florida Trends magazine's Legal Elite. He was awarded the Martin Luther King Jr. Foundation for Florida Humanitarian Award and is a Legal Services of North Florida founder of Justice. Judge Frank was elected circuit judge in Florida's Second Judicial Circuit in 2018. He has served as the presiding judge for juvenile delinquency, probate, and guardianship in Leon County, and is currently the circuit civil judge of Gadsden and Liberty counties. It's my pleasure to introduce Judge David Frank.
Okay, good morning or good afternoon, everybody. This is Circuit Judge David Frank. I am in the Second Judicial Circuit. Our seat is in Tallahassee, as you all probably know. I'm currently assigned circuit civil duties in Gadsden County and Liberty County. So we have 6 counties in the Second Judicial Circuit, and I do the circuit civil work for those 2 counties, Gadsden County, Liberty County. And let me just say I'm honored to be asked to speak to you. I practiced for I think just short of 25 years before I went to the bench, and it became very clear to me during my years practicing how important paralegals are to a law firm. Or a government agency, wherever you may be working. And so I do really, I'm very fond of this organization, and I would encourage you to continue to do these seminars and to have your continuing legal education and your outreach efforts, the work that you do to keep the paralegal community as sharp as possible. I think that's really important. I know in my practice, when I was practicing, that it was the work of the paralegal was absolutely critical. I mean, critical. It would it can make or break a case. What I wanted to talk to you about today, and the topic that I cleared with your executive director, is post-trial activity. In other words, what are some of the things paralegals should be aware of, and lawyers, of course, for actions that would be required once you have a jury verdict. And so we have 2 or 3 categories of actions that you would have to be prepared to address, and they would be motions for new trial, motions for verdict notwithstanding, judgment notwithstanding the verdict, and a remititure, additure, and 1 or 2 others. And I think it's important to just have the general thrust of these so you can guide your attorney, because we're talking about a jury trial, and so you can assume that your attorney is already exhausted and has been dealing with legal issues and evidence day by day during the jury trial. And so I think it's important to have a paralegal assisting who can sort of keep track and remind the attorney these are the things that we have to be careful for and we have to look for. And that would be whether you're filing the motion or if you're on the other end of the motion and have to respond to it. So and the only other thing, if you would allow me, that I just want to talk to you about for a minute, and it has to do also with jury trials, is the case management, active case management here in Florida. And I think it's the same across the state, but I know here in the Second Circuit, the trial judges have taken the Florida Supreme Court mandate on active differential case management very seriously. And we have diligently moved to implement that mandate. And what does that mean for law firms and agencies that are litigants in circuit civil cases? I think it means two two things primarily, if I could just sort of boil it down. One, case management is now going to be shepherded by the trial judge. Up to now, previously, it was the lawyers who managed their cases. And so I guess the idea was, look, if you want to let your case sit for 2 years, we don't care. Let it sit for 2 years. But there was an accumulation of thought that judges and lawyers were not moving circuit civil cases efficiently and timely. And that was already starting, and then the pandemic hit. And of course, during the pandemic, the jury trials were suspended. And so we had hundreds and hundreds of jury trials that just got backlogged. And so when we got the green light to go ahead and do jury trials again, we had it just made it tough on every area of law, because that backlog of civil jury trial cases just meant there was a squeeze on the timing for everything else. And so we had to become more efficient with how we handle cases. So it's a combination of those two things. The Florida Supreme Court had a committee look at proposed rule amendments, and there were admin orders issued by the Florida Supreme Court during the pandemic that for active differential case management procedures that have now been adopted for non-pandemic times. And I think it's really important that you know that, because if you approach a circuit civil case, especially a jury trial case, with the old framework in mind, it's gonna catch you. It's gonna put you in a bad position as you get closer to trial, because you may think that you can get a continuance and that you can do certain things, when in reality, under this new active case management, you really can't. And so the two things that it boils down to are how fast your trials are set, and how much time you get before the trial occurs. And second, whether you can get a continuance. And I would just say this, you know, the days when you could rely on just getting a continuance because it's the first one you requested, or getting a continuance because all the parties agree to it, those days are over. I mean, active case management requires a stricter determination of good cause to get a continuance, whether it's your first one or whether everybody agrees. And so you have to be careful of that, because if you think, well, if I don't accomplish certain tasks, when we get closer to trial, if we're not ready, I'll just ask for a continuance, or I'll just suggest and recommend to the attorney that you work for to file a motion for continuance. The answer very well might be today that you don't get it. And that would especially be true if you have discovery issues. And so let me give you an example. If you wait till a month before a jury trial is set to begin, and you file a motion and say, Judge, we need a continuance because the other side has not provided us answers to interrogatories, and they won't coordinate their depositions. They've been dragging their feet. There's a good chance that the judge might say, sorry, you should have brought that to me 6 months ago, not now. So whatever you didn't get, you're just going to have to go to trial without it. And I know that sounds harsh, but it is a matter of implementing this stricter analysis for continuances. It puts a very heavy responsibility, even though the active case management directive puts case managing, moves some of that responsibility and supervision from lawyers to the trial judge. At the same time, it puts more responsibility on the trial lawyers, on the lawyers involved in the jury trial case, puts more responsibility on them to bring discovery disputes and whatever matter might hold up your ability to prepare for trial, to bring those matters to the trial judge very quickly, as soon as they arise. It would be a mistake to sit on it and then close the trial, file a motion and say, Judge, we're not going to be prepared as we should be or we want to be because we can't get this information. And the plaintiffs, we asked for it 6 months ago and they still haven't given it to us. The judge might say, why didn't you tell me this 6 months ago? Because I could have fixed it 6 months ago. So be careful with that. Understand we're in a stricter environment for civil case management and remind your attorneys of that. Especially if you have attorneys that have practiced for a long time, they're very, very used to the pre-active case management framework, and that framework just isn't there anymore. And so you don't want to be caught a month before trial not having the information you need and maybe not being able to get it. So keep that in mind. I wanted to talk to you about active case management. I think that's important, and we're talking about what to do after a jury trial. So I guess the active case management part is just some guidance and some advice about what to do before the jury trial as you're preparing for a jury trial. And I think that's real important. And I thought it was important enough to take the time to talk about it today. So let's start. I prepared an outline. It's a 6-page outline, and I'm sure the executive director will get it out to everybody or post it somewhere. It's important to know how this outline is set up. These are not my words. If you see the title of the outline says preparation to address post-trial challenges to a jury verdict, case law excerpts. And then I say internal citations omitted. So this outline, it is my selection of key excerpts from the what I thought were important cases. This is not like a memorandum that I prepared or my own wording in an outline. Everything you see is a direct quote from the case I cite. Okay, I just didn't put quotation marks everywhere because it sort of starts to get distracting. So I'm just telling you up front, each one of these paragraphs is actually a quote. It's an extract from a case that I thought was important. And if you look at the first one, manifest weight of the evidence. So there might be an issue after a case where your attorney is convinced that the other side has not met its burden, its evidentiary burden for whatever the elements of the lawsuit were. And I have to tell you, so this is somewhat disfavored as regarding the approach of the appellate courts, I believe. And you'll see this first paragraph I have. This is somewhat typical for the appellate courts when there's an appeal and the issue is that one side did not that the evidence was just so inadequate that the case should be reversed on that matter alone. And you'll see this kind of language. This court, and this is Smith v. Lyles. That's the first paragraph on the handout. Let me just read this. The deference the law grants a trial court granting a motion for new trial based on the manifest weight of the evidence does not grant a license to operate, quote, as a super juror by disregarding a jury's verdict simply because the judge would have rendered a different one had it been the judge's choice to make. So what it's saying is you can't just take a second shot at the trial judge. The trial judge is not going to be a super juror and reweigh, and reconsider the evidence unless it's a pretty severe situation or a very clear situation that the evidence is lacking. And here's the other thing, and I want to really jump ahead in the outline, see if I can find it. So here's something that's real important too about the inadequacy. If you see on page, I'm sorry to jump around, but if you go to page 3 in the outline, the top excerpt, you see, and this is the Koba case, and this talks about the difference between an inadequate verdict and an inconsistent verdict, right? And so, if you look about midway through the excerpt, and I'll just read this, an objection to the inadequacy or excessiveness of a verdict can be raised in a motion for a new trial without requiring a party to object prior to the jury's discharge, right? But if it's a matter of inconsistency, and we'll talk about that in a minute, you have to do it right then and there, because if the jury is discharged, it's too late. And so, that is something to be keenly aware of. So getting back to page 1, this is really important. So we'll talk this. I'm not going to get into too much about motions for new trial regarding the manifest weight of the evidence, only to say that they can be tough. I think my reading of the case law, the appellate case law in Florida, is that they're somewhat disfavored, and so you really have to have a strong case for that. But the next item, I think, is maybe more important, but I think it's more prevalent, at least, and that is violations of motions in limine. You work with your attorney and you file motions in limine, and you say you're asking the judge to prohibit the other side from presenting or attempting to present certain pieces of evidence, right? Because they are not admissible under the evidence code. Well, what happens if you get the trial and the other side puts it in anyway, or tries to put it in anyway? Do you get a mistrial? Do you have to object? I mean, what happens? So I just want to talk about that for a minute. It is going to be a bad situation for the side that violates the motion in limine. In the first paragraph I have on this page 1, under violations of motion in limine orders, you see this person was prohibited in advance. That's what in limine means, in advance, from talking about a subsequent remedial measure, putting some cage in. But they found a way, and it could have been inadvertent. I'm not suggesting it was intentional. I don't think we can tell from here, but because of what the witness for this party stated in front of the jury, they basically conveyed the message that they put in this subsequent remedial measure, a cage. And the court says, this is when I say these things can be serious and a little scary. So this court says, even if a curative instruction is given, even if there's an objection and the court says, sustained, I'm going to instruct you, ladies and gentlemen of the jury, don't, disregard that. Now here, this court, the Martex Corp versus Artilles court, says, even if there's a curative instruction given, the skunk was already in the jury box. So what does that say? It says you may be heading for a mistrial, and a curative instruction might not be enough. And at the same time, you have to be careful not to ask for too much, right? Because the next case, which is the Rhodes case, the next paragraph, right here, the party asked the trial judge to strike the defendant's pleadings, and the appellate court says, well, wait a minute, okay, we recognize that what the attorney did during the jury trial was unacceptable, and I think it also violated a motion in limine, a prior order. But sanctions, but striking the pleading at that point was too severe. What the court should have done is impose sanctions directly upon the individual who it found had made intentionally misleading and deceptive statements to the court and or jury, and who utilized improper discovery procedures, right? So the court's saying, you know, to sanction, and it could be either the attorney, it could be the party being sanctioned, or it could be the attorney personally being sanctioned, right? So that's something to be aware of. The next paragraph down, here we have an auto accident case, and one of the standard motions in limine is to tell the you can't tell the jury whether a citation was issued, right? Because that's what the officer does that's investigating the accident. That's supposed to be separate from the facts that are litigated and presented to the jury under the evidence code. And so it's a valid motion in limine to say, Judge, we want you to preclude the whichever side from referencing the police report and the result of the police report, whether somebody was cited. So here, there was a motion in limine, but on closing argument, the attorney said this about the trooper's testimony, right? The lawyer was arguing on closing that the trooper had not rendered a single opinion about fault in the accident and had not formulated opinions regarding negligence or the propriety of lane usage being improper, as the reasonable inference to be drawn was that the party was not cited for causing the accident. That was improper. So by suggesting that the officer didn't express an opinion about fault, well, he wasn't allowed to, right? He wasn't allowed to. There was a motion in limine, and it's a very standard motion in limine. So the court granted that motion in limine and said, yes, the trooper is not to talk about, you know, citing the driver or not citing the driver. Well, the attorney then, by saying this to the jury, that the trooper didn't render any formulated any opinions regarding negligence, he's using the order granting that motion in limine to his advantage, and that's improper. You can't prohibit the other side from saying something and then tell the jury, and then use that to your advantage and tell the jury, and he didn't say anything about that. You know, you can't do that. And so the court says that the orders in limine prevented the party from addressing the depth of the trooper's investigation or his opinion regarding fault. And so it's axiomatic that it is improper for a lawyer who has successfully excluded evidence to seek an advantage before the jury because the evidence was not presented. And that makes complete sense, right? But you have to be careful, because I don't think, you know, there are some attorneys that I don't think are fully aware of that. And so you want to be aware of that. Okay, so the next section is improper comments during closing argument. And there are some things that have to be, that you have to be aware of here, right? And so let's, the key case on this is Murphy, and I'll give you the site in a minute. Well, it's right there on page 2. So Murphy says, it's a Florida Supreme Court case that says, you really have to object when the improper comment is made, right? So that there can be a curative instruction. If you don't, and you also don't raise it in a motion for new trial, you've waived it completely. But if you raise it, if you forget, the best course obviously is to remind your attorneys if there's an improper comment and you think it rises to the level where you think an objection is necessary, you have to object at that time. If you don't, and you don't raise it in a motion for new trial, then I'm sorry, if you don't object during the closing argument, but you preserve it by objecting and making the argument in a motion for new trial, then you have to apply the 4-part test of Murphy. Okay, and so if the issue of an opponent's improper argument or conduct has not been preserved by contemporaneous objection and a motion for mistrial, a new trial will only be warranted when the improper behavior is of such nature as to reach into the validity of the trial itself, to the extent that the verdict could not have been obtained but for the comments. What the Florida Supreme Court is saying is it's a very high threshold, right? And so, and let me repeat this again. I might have stated it incorrectly. Let me make sure I state how this works. If an opponent's improper argument or conduct has not been preserved by contemporaneous objection while the closing argument's being made, and motion for mistrial, right? A new trial will only be granted when it is an extremely high threshold. Here's a 4-part test. 1, that the challenged argument or attorney misconduct was 1, improper, 2, harmful, 3, incurable, and 4, so damaging to the fairness of the trial that the public's interest in our system of justice requires a new trial. Very high threshold. That's the Murphy case. And I have the site there on page 2. And by the way, it's improper comment during closing argument and instances of attorney misconduct. It's for both. Okay. All right. And let me jump over to page 3, which is inconsistent verdicts. And we started to talk about this. And so the first paragraph sort of lays it out for you. Courts will distinguish between cases involving inadequate verdicts from those that are characterized as inconsistent. And a verdict is not necessarily inconsistent because it fails to award enough money or even no money. In those circumstances, that's the inadequacy or the adequacy of the award, not the consistency with any other award by the verdict. So you can object to the inadequacy or excessiveness of a verdict in a motion for new trial, and without objecting prior to the jury's discharge. Okay. But for an inconsistent verdict, as I mentioned earlier, that must be raised before the jury is discharged. And you can see that in the next passage, and up to the top of the page. And they give an example of the difference between a verdict that's inadequate versus a verdict that's inconsistent, because you have to really understand that distinction. And sometimes it becomes a somewhat of a close call. But so where it is, you have to, if it's inconsistent, you have to object before the jury's discharged. And the last paragraph or last sentence of the first paragraph, you see that is so strongly upheld, that idea that if the trial court erroneously denied a challenge to an inconsistent verdict, then the proper remedy is a new trial rather than entry of judgment in favor of the objecting party. So you absolutely must raise an objection to inconsistent verdict, and that second passage on page 3 gives a great example that you can read and understand the difference between the two. And then we come up to JNOV. That's the judgment notwithstanding the verdict. And there are some things here to be very much aware of too, because if this is not done properly, again, the repercussion it very well could be and almost is mandated to be waiver. You know, you waive the argument, and so you will not be able to appeal that. So first, let's talk about the standard. The standard is actually the same standard as the standard for a directed verdict. Now, I know recently Florida state courts, you know, have adopted the federal standard for motions for summary judgment. But we're not talking about that here. We're talking about the standard for directed verdict. That has not changed. And so that's because the standard for a JNOV, judgment notwithstanding the verdict, is the same as the standard for a directed verdict that a party would argue during the trial. This is after the trial, but it's the same as the directed verdict standard that you would encounter during the trial. That's why under JNOV, I start with the directed verdict blurbs, if you will. So the first one sort of gives you the good standard for the directed verdict. It is only where there is no evidence upon which a jury could properly rely in finding for the non-moving party that a directed verdict should be granted. The same standard applies when a court addresses a motion for judgment notwithstanding the verdict. Okay, and then the next sentence: a trial court should grant a motion for directed verdict when the evidence, viewed in the light most favorable to the non-moving party, shows that a jury could not reasonably differ about the existence of the material fact, and the movement is entitled to judgment as a matter of law. And so this is something that's a high threshold too, right? Because again, it's not inadequacy or inconsistency, right? It's saying on a certain element that was required as a part of the lawsuit, there is no evidence, right? There's no evidence, or whatever evidence that was offered was so weak that it doesn't count. These are my words. It's so weak that it doesn't count. And so this is a high threshold too. And so then it talks about a case. Let me see. I want to make sure we're okay on timing. You see that. Let me just go through this case real quick because I think it's very instructive. The plaintiff presented evidence from 3 physicians that her auto accident related neck injury was permanent, while the defendant's fully qualified medical expert testified that she had not sustained a permanent injury or permanent aggravation of a pre-existing condition. In the course of trial, plaintiff's motions for directed verdict on the issue of permanency were repeatedly denied. After the jury returned a verdict finding no permanent injury, the trial court granted plaintiff's renewed motion for directed verdict or motion for judgment notwithstanding the verdict, finding that the defense doctor's testimony to have been incredulous, confusing, mistaken, and not reasonable. Sounds like what I was saying a minute ago, right? So weak that it doesn't count. Well, we'll see what happens here. So the first district reversed, employing a de novo standard of review, which required it to determine that if any reasonable jury could have rendered the verdict that the auto accident in this case caused no permanent injury to the plaintiff's neck, then JNOV is not proper. So it found that the defense medical expert was clear and unwavering in his testimony that there was no permanent injury. The first district found that it was clearly a jury issue and reversed. So the argument that any or all surgical treatment of an accident-related injury mandates a finding that plaintiff sustained a permanent injury has been made before and rejected. And so the first district is saying No, there was evidence, and it wasn't so weak that it didn't count. And so that kind of gives you a guideline. And then here's a case, the last paragraph there before we get to the last section. It's the Martinez case. A party waives the issue of legal sufficiency of the evidence by failing to move for a directed verdict on that issue at time of trial. So here you go. We said before that you don't have to, we talked about inconsistent challenges to the consistency of the verdict versus adequacy. Well, here's an important statement, right? A party would waive the issue of legal sufficiency of the evidence by failing to move for a directed verdict on that issue at trial. Okay. And so finally, Rule 1.530. So this is, the motion for a rehearing, and we've had recent amendments, and I wanted to talk about these just very quickly. And I know we're covering a lot, but and you should read this recent amendment, the recent amendment to Rule 1.530. My first paragraph talks about some procedural things. It moves the sections on remediature and editure from a different rule into this rule. And it also talks about it's using different terminology for the event that you start the clock, where you start the clock, right? And it talks about to clarify when the deadline to file a motion for new trial or motion for rehearing begins to run, the phrase 15 days after entry of judgment was changed to 15 days after the date of filing of the judgment. So there was some ambiguity over entry of judgment, and they're trying to clarify that by saying filing of the judgment. And then I talk about how some of the sections were moved from one rule into 1.530. And there's two things I want to, in this section, I want to cover with you. And first is I want to just make sure we are still on within the time period. See, here are the two things. Here's the first one: to preserve for appeal a challenge to the sufficiency of a trial court's findings. You know how there's statutes and rules and case law that says for certain types of final judgments, the judge must make findings, put findings in that final judgment, right? You've seen that. You've seen it in family law and in some other areas. Well, if a party wants to challenge the sufficiency of the trial court's findings that go in that final judgment, right? Listen to what it says. If you have a situation where you want to challenge that, to preserve for appeal a challenge to the sufficiency of a trial court's findings in its final judgment, a party must raise that issue in a motion for rehearing under this rule. Like, that's new, and that's important. You must raise that in a motion for rehearing, or you don't. It's not preserved for appeal. And I cite the case. I cite the rule. Well, actually, I give you the Florida Supreme Court site for the rule amendment, and you should read the commentary on that, and you should recommend, or when you're chatting with your attorney about getting ready for a jury trial, include this in your discussion, because 1.530, rehearing, this is an important change. And then finally, the last thing I want to talk to you about, there's a case that came out, and it's Coates. It's a Florida Supreme Court case, January 5th, 2023. The Coates case made a pretty important, and I'm talking about this because I think the case had to do with remediature, right? And so Rule 1.530 now has remediature, right? Additure, the party is requesting is challenged the verdict, saying not enough money was awarded. Remititure is a party challenging the verdict, saying too much money was awarded, right? Well, so that's why it's coming under 1.530. So this case, the Coates case, and have the site. This is the final paragraph or final two paragraphs or final paragraph on page 5, and it goes over to page 6. Previously, if there was a challenge to the excessive, if there was a challenge claiming that a punitive damage award was excessive, there was an analysis. The analysis would be whether it's whether it should be within the 3-to-1 ratio. In other words, is the punitive damage award more or less than 3 times the compensatory damage award? And previously, that's all the analysis that you needed to make. And I want to read this because I think it's important. The court said, talking about the decision below, though we cannot say it was unreasonable to conclude that the facts and circumstances supporting a departure from the 3-to-1 cap. So you can have facts and circumstances that would justify departing from the 3-to-1 cap. And that was it. As the court goes on to say, section 768.73 subsection 1, as we have explained above, is that is not the end of the inquiry. Rather, section 768.74 5D imposes a further check on an excessive punitive damage award that turns on whether the amount awarded bears a reasonable relation to the amount of the damages proved and the injury suffered. So even if it's within the 3-to-1 and the damage is proved, there has to be a further analysis to compare the damages proved to the injury suffered, right? And then the court in this specific case said, looking to the undisputed facts in this record, no reasonable trial court could have concluded that the $16 million punitive damage award survives that check. So what they were saying is, okay, it was either within the 3-to-1 ratio, or it was properly determined to be one of those cases that circumstances would go beyond that cap. Either way, when the analysis of the damages proved to the injury suffered was done, that test the party did not pass, right? And so this is an additional analysis that the court is adding to a punitive damage challenge. And so reading these statutes together, this is the sort of the conclusion. Unless the facts and circumstances exception of 768.73 1B applies, section 768.73 1A caps on an award of punitive damages in comparison to the compensatory damages award at a ratio of 3-to-1, and section 768.74 provides for further review of an award that is challenged as excessive, regardless of whether the award falls inside or outside the 3-to-1 cap. So it's really saying there's two steps, not just one. It's not just the 3-to-1 ratio step. You know, does it fall within that cap, or does it pass the reasonable circumstances to be able to go beyond it? What they're saying is that's not the end of the discussion. Even if that's the situation, you have to then have an analysis of comparing the damages proved to the injury suffered. And if you read that case, it explains how that analysis is accomplished. So that's different. And so this, we're really approaching the end of our time here. I just have about 2 more minutes. What I'm trying to do you just, I hope. All I'm trying to accomplish is even though I'm probably pretty boring and I've been reading a lot of passages, I'm trying to get you interested in post jury trial activity. I'm trying, my real message to you is be careful. If you're going into a jury trial, think ahead of time about what you have to do to either keep that jury verdict that you get or to challenge one you don't like. Okay. And these are, I think, the main things that you really have to read up on. And you can start with the cases that I've cited in this 6-page outline, but you've got the arguments regarding the manifest weight of the evidence. You have violations of motions and limine orders. You have improper comments during opening and closing. You have inconsistent verdicts, and you have judgment notwithstanding the verdict, JNOV, and then finally you have Rule 1.530. I think if you would take some time and review those areas, including recent case law and recent amendments to rules and statutes, even, you'll be better prepared, because even though all your energy and resources are going to be directed towards getting that verdict that you think is the fair verdict for your client, you have to be ready for what happens from the moment that verdict comes into the courtroom. There are going to be things that you have to do, that your lawyer has to do to preserve certain arguments, legal arguments, right? All right. Well, thank you very much for your attention. I am at, you can get my phone number and email on the Florida Bar site. It's Judge David Frank, Second Judicial Circuit. And if you had any questions about any of these things, you can certainly email my judicial assistant, Tracy, or call, and I'd be glad to talk to you. And I hope I hope that soon you return to your live conferences. I'd love to attend and meet everybody, but I hope I was able to sort of focus you on some of these issues for what happens when that a foreperson stands up and reads a verdict in the courtroom. So thank you very much, and I wish you the best in your practices.